All right, welcome once again, Disability Law Show. Good to have you along over the next 30 minutes. John Scholes here, along with partner Samfiru, Tumarkin, LLP, James Fireman, also in attendance, back this week. A lot of stuff to get through. We got 30 minutes of runway, so let's tuck in and get it done. You want to reach out anytime to James, by the way, or his very capable team, 1-855-821-5900, help@disabilityrights.ca. And lots more contact throughout the show. We'll be sure to give that to you, how you can reach out. If you're dealing with an insurance company, you've been asked to appeal, maybe for a friend, a family member, a colleague, this show is for you. Again, you're going to learn a lot over the next 30 minutes, and you have correspondence every week on the show as well. And you can catch our radio show. Just go to disabilityrights.ca to find a station near you that carries that. Coming up, James, 3 ways the right disability lawyer can help with your disability claim is denied if that happens. That's coming up. First, though, pal, week that was. What do you got?
Well, so I always like to start the show by talking about some of the things that people don't understand about disability insurance law. One of the things that is frequently misunderstood is that you don't actually need a specific diagnosis in order to be qualified for disability benefits. So if you're covered under a long-term disability plan and you are suffering from symptoms which are preventing you from being able to work, you're not functionally able to do the job that you had at the time that you became disabled, then you're entitled to those benefits, even if your doctors aren't able to figure out exactly what it is that is causing your disability. And that's a situation a lot of people find themselves in. And so a recent case that I had involved a lady who suffered a illness early last year, February of 2020. She had extreme fatigue, fever, shortness of breath, cough, and she got over the fever but never really recovered. Never really recovered. She continues to have all these symptoms 18 months later. She is still completely unable to do any type of physical activity. Even walking a single block will require her to rest for a couple of hours. That's just the type of disability that she's dealing with, and she's just not able to function in any kind of a work environment. Now, after the fact, probably some 6-8 weeks later, her doctors realized this might have been COVID, but it was far too late to test for it at that point. At that point, the virus would have passed if that is in fact what she had. So we have no way of knowing exactly what it was. But it does sort of fit the timeline. She might have been one of the very early cases, maybe not.
Sure.
And she may well be one of the people who are suffering from the long COVID, the long hauler COVID that we hear about in the news all the time. Whatever the issue, whatever is causing her symptoms though, that really does not matter. If you take a look in your long-term disability policy, you're going to find that there is nothing in there that speaks to requiring a specific diagnosis. The test focuses on your ability to do your occupation or having a disability that's preventing you from doing that occupation, not a specific diagnosis. And so if you're out there and you are suffering from an illness and you're not sure exactly what it is that's causing it, and your doctors haven't been able to pinpoint it, you're still likely going to be entitled to disability benefits if it's preventing you from working. Now, that doesn't mean that just because you say that you're having these issues that your insurance company has to agree with you. You do have to be able to show that you are legitimately suffering from it. In my client's case, she has gone through over the last 18 months, I can't even count the number of different tests and assessments that she's gone through, the number of different specialists she's been referred to, the number of different medications she's been on. So there's really no question that she's suffering from some illness. We don't know what it is, but she's suffering from something and doing everything she can to treat it, and she still isn't able to make it right. Her insurer denied the benefits. They're going to pay for that, though, because they never had her assessed. They just said, no diagnosis, so we're not going to pay your benefits. And that is a big no-no. The courts have said several times in LTD cases that if you base your decision on a lack of objective medical evidence, on a lack of a diagnosis, that is an improper basis for a denial. And so what they've done is they've now exposed themselves not only to having to pay the benefits that she's entitled to, that she should have been paid over the last 18 months, but also to the potential for having to pay for what's called punitive damages. And essentially that is a court stepping in and saying, not only were you required to do this, but your process was fundamentally unfair. And as a result, you're going to be punished for the way that you've handled this claim. And you're going to have to pay an amount over and above the benefits that you owed as a deterrence to doing that kind of thing in the future.
It would seem that the insurance company would know this already. I mean, you think 15 years ago we didn't know medically what we know now. Imagine what we'll know in another 50 years, right? But you'll still get denied. You may still not have a diagnosis.
I don't think it has anything to do with what the insurer knows or doesn't know. I think they understand very well what's going on. I think the issue is much more they know that most people that they deny in those circumstances are not going to understand that a lack of a diagnosis doesn't prevent them from having a disability claim, to being able to receive those benefits. Most people will hear that and say, well, I guess that's true. I don't have a diagnosis. I guess that means I'm not entitled. Yeah. Not at all true. Even if you don't have a diagnosis, if you are suffering from a medical condition, even if it's unknown, that's preventing you from working, you are still entitled to your benefits.
I can see the light really being shone on this when it comes to mental illnesses, because they just don't show up in an X-ray generally, or a CT scan or anything, right?
Yeah, I'm really happy that we're in a time now where people really understand mental health a lot better than we used to, even going back 5 years, but certainly much better than 10, 15, 20 years ago when I started practicing. And so, it's not the case anymore where people who suffer from mental health issues are automatically going to be denied. There are mental health claims that are approved even right away, but it's still an issue. It is still something that is more difficult for people to understand and accept as being disabling than something that you can see in black and white, where it is a physical issue. So there definitely is still a big gap in how those claims are treated. I'm just happy that that gap is smaller now than it once was, but still a lot of work to be done.
You mentioned even though even your doctor, your medical team may not have a proper diagnosis, if you have a doctor's note, for lack of a better term, if you have that should be enough for the insurance company to say, my doctor says I cannot work, I cannot perform the functions of my own task, thereby I qualify for disability.
Yeah, I quite agree. As long as your treating doctor is confirming that you are suffering from a disability, a medical disability that's preventing you from working, whether they understand the cause of that disability or not is irrelevant. If your doctor is saying, your treating doctor is saying that you are suffering from a disability preventing you from working, then yeah, you're absolutely right. You should be entitled to receive those benefits.
There is a website you can go to. Anyway, we talk about this on our employment law show with Lior as well. And I know, James, you've used it. You've referred to it, pocketemploymentlawyer.ca. I know it says Pocket Employment Lawyer, but there's a pretty good section, a pretty robust section on disability law and questions you may have. It's free. It's anonymous. You can go there anytime. Again, pocketemploymentlawyer.ca is what you want to use. Want to move on to an email. Again, help@disabilityrights.ca. This one for you, James. Patricia writes in. She says, after a review of my medical information on file, the insurance company determined that I don't meet the definition of totally disabled according to my policy. This is simply untrue. I'm being treated by a physician, and my doctor says I can't complete the daily tasks of my job. Should I appeal their decision to deny my benefits?
Well, listen, my friend, the first thing is, let's just go back to what we were talking about a moment ago. Her doctor, Patricia's doctor, is confirming that she isn't able to do the tasks of her job. She's entitled to benefits. And so the question is, now that she's been denied, what does she do about it? So there's really 4 options here. Okay. Number one, if you're denied, if you are actually able to go back to work, that is your best option. If you can return to work, earn 100% of your income, that's what you should do. You're going to be far better off in every facet if you return to work, as long as you're medically able to. But if you're not medically able to go back to work, you've really got 3 options. Option number 1 is to do nothing. That's your worst option. You're basically just saying, I can't work, I'm entitled to these benefits, but I'm going to allow a billion-dollar insurance company to keep money that I should be entitled to. It makes no sense. Please don't do that. Option number 2 isn't much better. Option number 2 is the appeal route. And so the appeal, people do this because they're invited to do this by the insurer, and they think that that is the proper channel in order to dispute a denial from their insurance company, because that's what's presented to them. But the reality is the appeal is not something that is required in the process. If you look at your LTD policy, you will not find anything in the policy that refers to an appeal process. It's simply not there. It is not a part of the process that is required. So why is it there? The insurance companies allow you to appeal because they do not want you to take control away from them. When you appeal, all you're doing is you're asking the insurance company to reconsider their decision. There is no formality to the process unless the insurer decides to put that in there. But there is nothing that requires the insurer to give this to an independent body or even to somebody different than the person who made the decision in the first place. They, more often than not, will send the appeal to the same person. And sometimes when you appeal a second and third time, they'll keep sending it back to the same person. And so what the appeal is essentially just a way for the insurance company to prevent you from taking control away from them. And how do you do that? Well, you do that with option number 4. And option number 4 is bringing a legal claim. It's what the insurance company doesn't want you to do, because as soon as you do that, both you and the insurance company now have to play by the same set of rules, and the insurance company doesn't get to dictate what those rules are. You're now on a level playing field. And if you're hiring an experienced LTD lawyer, then you're going to have an advantage, and that's the last thing the insurance company wants. So to answer your question, Patricia, a lot more briefly than I've just done, no, don't appeal. Don't appeal. Call us, we can start a legal claim, and we can move forward and get things done pretty quickly.
And I think that there's decent evidence that if you appeal long enough and it goes on long enough, you might pass a 2-year time limitation, right?
Sure, and
That's
that's absolutely a part of it. You know, once you're denied your claim, you have 2 years from that date when you receive the letter in order to start the legal process. If you don't start a legal claim within 2 years, you're not going to be allowed to after that. And as soon as that 2 years passes, John, you better believe the insurance company is going to have zero interest in listening to any further appeals. Before the 2-year mark, they'll listen to however many appeals that you want to do. I've had clients that have literally appealed 6-7 times before they contacted me in under 2 years, and we were able to issue a claim before the 2-year mark. They will continue to listen to your appeals as long as you want to until the 2-year mark is up.
Short break, lots more to go. In fact, coming up, the 3 ways the right disability lawyer can help with your claim. That is on the way. In the meantime, 1-855-821-5900. help@disabilityrights.ca is the email address as well. We'll continue the Disability Law Show. Stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thanks for sticking around. John Scholes here, and alongside partner in Samfiru, Tumarkin LLP, James Fireman, the most positively reviewed disability law firm in this country. You want to reach out and get the compensation you deserve, the money that is owed to you, no matter where you are in Ontario or BC or Alberta. Reach out to us. We'd love to talk to you and give you a phone call, 1-855-821-5900 to reach James and his team. There's also ltdfaq.ca. There's a website you can check out, ltdfaq.ca. But James, as promised, let's get into this. Answer some questions. 3 ways the right disability lawyer can help when your disability claim is denied. Number 1, the right disability lawyer will take over, I love this one, all communications between you and your insurance company. Tell me about it.
Yeah, so this is a really big aspect of what we do. As soon as a client calls us and signs a retainer agreement, the first step we do, the very first thing we do, is we write to the insurance company and we let them know that we've been retained. From that point forward, they are not allowed to communicate with our client anymore. Anything that they want to say, they have to say through my office. And that is a wonderful thing for many of our clients, because a lot of the stress and anxiety that our clients are dealing with has to do with dealing with an insurance company, not understanding the process, not understanding what they're supposed to do next, and having this large insurance company with all of these resources as an opponent. They don't really know what to do, they're scared, and they're not really sure how they're going to get through this, how they're going to get the benefits that they need, and they're in a position where they're in great financial stress as well too. So this is just another element that's added to it. So we remove that right away. As soon as they call us, they don't have to deal with the insurance company anymore. And it's interesting because I just had a lady call me yesterday, and she called because she's been dealing, she hired another law firm to handle her claim in June. And she hasn't heard anything from them. She called, didn't get a call back, but found out that they haven't contacted the insurance company yet because the insurance company is still contacting her. And so I said, well, the good news is as soon as you sign the retainer, that's going to stop right away. And that is a huge benefit for many clients, especially those who are dealing with mental health issues, who are dealing with anxiety and depression already. When you're adding the stress of having to deal with an insurance company, that's obviously going to compound the problem. And so that is a good first step in terms of their recovery from a medical perspective.
Number two, things that the Right Disability Lawyer can do to help with your claim. And this one again, explain this one a little further though. It says you will demand a copy of your entire file from the insurance company. I can't get that.
Well, you can ask for it. So if you're an individual who has a claim, you can ask for your entire file. And sometimes you'll get it, sometimes you won't. Sometimes you'll get the runaround, or you won't get your message returned at all. As soon as we start a legal claim, in fact, even before that in most cases, the insurance company is going to provide us with the entire file because they know they have to. They don't have a choice. Once you start the legal process, they have to give up their entire file. And that means not just the documents that you send them when you start the claim, those initial documents where your doctor will fill out a form and your employer and you'll fill out a form. We're going to get those, but we're going to also get all parts of the medical file that they have. But better yet, we're also going to get all of their internal memos, and we're going to get access to any medical information that they got on their own. So if they were relying on any outside doctors to review and provide them with their opinion on the file, we're going to get that too, and that's often a treasure trove. There is often a lot in there that is very helpful to my client's case, where the doctors will tell the insurance company that, yes, this person is disabled, and rather than actually listen to what their own medical opinion is saying, they'll just ignore that, cherry pick whatever they want out of the existing medical file, and deny a claim.
We'll just sweep that underneath here. No reason to show James that until he's legally told to show you all that stuff, right?
In most cases, when people don't hire a lawyer and don't start this process, they're never going to get access to the file and understand that the insurance company knew very well that you were insured, and that's often the case, far more often than you would like to know.
Before I move on to number three, what else might you find in that file? I'm thinking something like hours and hours of surveillance that the person didn't know about.
Sure, there can be surveillance which can be very interesting. That's usually only revealed to the insured, to my clients, if there is something really damning in there, or they'll cherry pick one or two things and take them out of context. What I look for anything in the insurance file, though. I'm not necessarily looking for any one thing. I'm looking for anything. And if you keep your options open, you never know what you're going to find. In one case, there was an insurance company that included all of the invoices that they had paid for treatment. And you might be thinking, well, this is a good thing. The insurance company is paying for the treatment. And generally speaking, I'd say yes. But here's the thing. They'd paid for something like $70,000 worth of treatment, worth of rehabilitation treatment. And it was very clear from the treatment records that my client was not getting better, and they still cut my client off. And it became pretty clear to me that they had spent that money expecting to get a result that would allow them to stop having to pay the benefits, and it just wasn't there. And someone made a decision that was, well, we've spent all this money, so we've done what we need to do. We're not going to pay anymore. Well, they can't do that. And that evidence there of all the money they spent actually was really good evidence to use against them.
We are talking three good ways that getting the Right Disability Lawyer can help your case in your denial. Third one is this: the Right Disability Lawyer, James, will place tremendous pressure through legal means on your insurance company and force them to pay what you are owed. That's what the commercials say, right?
Yeah, and this just goes back to the second point. That insurance file, going through that insurance file and finding out all of the things that the insurer is hoping that you don't see. all of the corners they've cut, all of the ways that their process is fundamentally unfair, all of the times they've ignored your treating doctors or even doctors that they've hired for medical opinions that have made supporting comments. Everything that they've done that is unfair, I'm going to go through that file and I'm going to present a very detailed record of everything that they've done so that they understand that if they don't come to the table with a very reasonable offer for my client, and this has to go to trial, it will be very embarrassing for them. And if there's enough there, there's going to be exposure to the punitive damages that we talked about earlier in the show. Which means if it's there, the insurance company is going to be exposed not just to having to pay the benefits that they should have been paying all along, but also to paying punitive damages, sometimes in 6-7 figures. And 7 figures is the high watermark right now. And so it can be very expensive for an insurance company to make those kind of mistakes. And so they have to be very, very careful.
There is no way that anybody on their own is going to be able to pull this off without the right disability. There's no way. The door's not even going to open.
Well, no, there's no reason why the insurance company would entertain that because there's nothing that forces them to come to the table.
No legal trigger, right?
Absolutely not. There's nothing that will make them act reasonably unless you start a legal claim.
MyDisabilityQuestions.com. There's yet another resource for you to reach out and ask your questions. We will get to one of those, but I got to take a break first, so we'll do that. In the meantime, reach out to James and his team. Don't hesitate. Have a conversation, right? 1-855-821-5900 and help@disabilityrights.ca. This is a Disability Law Show. There's more coming up.
Think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back, Disability Law Show. Good to have you along for the stretch. 30 minutes is what we do every week, and you learn lots for sure. You want to reach out to James anytime, you can do so. 1-855-821-5900. You have questions of any other nature. There's a free and anonymous website called MyDisabilityQuestions.com. It's also got a searchable database, right? So you can see by typing in the gist of your question if something similar or maybe the same question has been asked in the past and answered. If not, leave it there, and the team will get to it. This one from Alton. James, he says, after being on LTD for almost 2 years, my insurer has informed me that I will be cut off in a few months. It seems to stem from their desire for new medical information, but my situation hasn't changed. The adjuster believes I can do office work, but my doctor doesn't. I've been a tradesman my whole life. What can I do?
Well, Alton, I appreciate the email. I think we need to take a step back and understand the process a little bit better, make sure that our viewers are on the same page.
Sure.
So after you are approved for long-term disability benefits, there's a 2-year period in most standard policies, which we refer to as the own occupation period. And what that means is during that period of time, you're entitled to continue receiving your benefits if you are disabled from your own occupation. If you have a disability, a medical disability that is preventing you from doing your own occupation. At the 2-year mark, which is referred to as the change of definition date, at the 2-year mark, the test changes. It now becomes whether you have a disability that's preventing you from doing any occupation that you are qualified for by training, education, or experience. And so it is a more difficult test to pass for sure, but in many cases, you're still going to be qualified before and after. And so what's happening here is Alton's insurance company is saying at the 2-year mark, well, yes, you've been disabled for these 2 years. Presumably it's a physical disability that was preventing him from continuing on in his occupation as a tradesman. But after the 2 years, he's capable of doing, I'm guessing, probably something more sedentary. Well, that may be true, it may not. I don't want to make too many assumptions about Alton. Presumably, he doesn't have a lot of experience doing sedentary work, but it may be possible that there is a sedentary job that he can do. But here's the thing. At the 2-year mark, it isn't just about finding a job that you might be qualified to do. There's actually 3 parts of the test. One, you have to be medically able to do some other occupation. That's a given. Let's assume in this case that the insurance company has found another occupation that Alton is medically capable of doing. 2, you have to be qualified for it or able to become qualified in a reasonable amount of time. Let's even assume that Alton is able to be qualified for whatever sedentary job the insurer has identified. The third thing the insurer is going to have to show, though, is that that job is going to pay a commensurate wage. And that's where a lot of insurers are going to cut corners. What that means is that after 2 years, if the insurer wants to say that you are capable of doing some other occupation that you weren't doing before, they're going to have to show that that's going to pay you roughly 60 to 65% of what you had been making before you became disabled. And that's a test that is often not passed even after the 2-year mark. So if Alton is a tradesman, there are a lot of tradesmen that are making low 6 figures.
Oh,
and
yeah.
they can pay very, very well. And so you're looking at 60, 65%, that's maybe $65,000, $70,000. If you have no experience or training doing sedentary work, you might be able to find a sedentary job, but you're not going to find one that's going to pay you that much. Not without several years of experience and probably some more education. In short, I really doubt the insurer is going to be able to show that you don't pass the any occupation test, and so I'd be very surprised if you don't have a good claim.
Where does that 65% come from? Is that what you would be making if you were still on claim with the insurance company?
Yeah, it's more or less what the courts have found in looking at other cases. There isn't any definitive rule, which is why I say 60 to 65%. But if you look at all the other cases, and that's really what we do, we look at what the courts do when they're presented with these cases. If you look at what the courts have done, generally speaking, if you're able to make somewhere between 60 and 65% of what you had been making before, the courts are going to say that's a commensurate wage, you're no longer entitled to benefits. And you're right, that happens to coincide very well with what most policies are going to pay you. Most LTD policies are going to pay you somewhere around 2/3, 60%, 2/3 of what you had been making before. So as a rule of thumb, if you're not able to replace the benefits that you had been getting up to the 2-year mark, you are probably still entitled to those benefits afterwards.
Want to get to an email here from Marie, our last few minutes of the show. help@disabilityrights.ca, by the way, says, I suffer from severe anxiety and panic attacks, and I'm currently on LTD. Both me and my doctor have advised my insurer that their verbal interviews are triggering. I've asked that the interviews be done in writing, continue to provide medical documentation every time it is requested, and have been very accommodating. This is all extremely stressful and makes my condition worse. What can I do?
Well, first I want to know, I think, Marie, you've done the exact right thing so far. Putting your request in writing is great. Supporting that with a doctor's note is fantastic. What you are trying to do is accommodate the insurance company as much as possible. And that's really smart, because if your insurance company is paying you benefits, even if there's a part of the process that is triggering for you, you want to extend the period of time that they're paying you your benefits voluntarily as long as possible. You want to avoid having to start litigation, having to dispute a denial, because obviously that means there's going to be a period of time where you have no money coming in. So first of all, excellent job to date. What do you do going forward? Well, I assume because you're writing that your insurance company is continuing to call despite the request to put the communication in writing. Well, I would take 1 or 2 more opportunities to continue to put that in writing. I would one more time ask your claims handler, please, I've asked you before not to communicate with me by phone. My doctor has advised that it's triggering for me, it is making my condition worse. Kindly continue all communications in writing, something to that effect. And hopefully they're going to abide by that. If they don't, then try one more time, but this time I would ask to speak to the claims manager, the supervisor above your claims handler. And if that doesn't work, then you're going to have a decision to make. You're going to have to decide whether or not it's worthwhile to continue having these conversations by phone, which are triggering and making your condition worse, but are still entitling you to the benefits, or risk getting your benefits getting cut off by saying, I'm not going to pick up the phone for you anymore. I'm only going to do this in writing. And that's a decision every person's going to have to make for themselves, because there is a consequence to it. Your benefits are likely going to be cut off if you refuse to communicate with the insurer the way that they want you to. At a certain point, it may be worthwhile for you to say, no, my mental health is too important. I can't continue doing this. If they cut me off, they cut me off. I'll start a legal claim and go from there.
Even with medical backing, they'll still continue to do this.
Some will, some won't. There are insurance companies that will abide by it, but not all of them will.
Lots of good stuff on the show today. Here's how you reach out now that we're done with this 30 minutes. Appreciate you sticking around for it. 1-855-821-5900. help@disabilityrights.ca. Just disabilityrights.ca is the website to find the long-running radio show as well, and mydisabilityquestions.com as well. We'll catch you next time. Disability Law Show.